I'm on. Go ahead.
Uh-oh. Okay.
Go ahead.
She's muted.
She's muted. But she should be able to hear.
Oh, Camille, can you hear me? Can you hear me? Camille? Tell her she's muted.
You're muted, Camille.
Hello.
Okay, so Camille, what I'll do, because nothing's being broadcast yet, when I say I'm getting ready to broadcast, then that's when you come in, when I say I'm broadcasting. So we're not there yet. We got 3 minutes. And so I'll say broadcast now. And then at that point, that's when everybody will come in and you can, so just count to 3 after I do broadcast and give me time just to invite everybody in. Okay?
Okay, so there's no music, no talk.
No, right now they're in the waiting room. Yeah, right now they're in the waiting room and they see our logo and it says welcome to the webinar. So that's what they see right now. And I think I have a message out there to remember to do the post survey at the end. So, okay. So when I say broadcast, that's when we'll go. And so count to 5, okay? Count to 5 after I say broadcast. Okay. We'll be doing videos, y'all. With the, I know I'm tired, it's non-video participants. Okay, so I'm kidding. And so do everybody want to go ahead and hide their video now?
Yeah.
Okay.
And my employee thank God doesn't have. Okay. He's like, Jesus, he said he has a bug and they gave him antibiotics.
And mute, except Camille, and don't forget to unmute. Let them know that. Don't forget to unmute.
Don't forget to unmute.
Okay, and I'll text you guys when I shoot the email over. I'm almost finished.
Maybe we put everybody in the text.
But you know this jackass.
Almost there, y'all.
Camille, you need to stop your video.
Video?
Stop your video.
Yeah, turn your video off. There you go.
Good evening, everyone. I'm Camille Whitworth, and I'm honored and I'm thrilled to serve as the moderator of this webinar, which is sponsored by the Crescent City chapter of the Links Incorporated, which I am proud to be a member. Tonight's important topic is what you need to know about successions. Now, for anyone who's been involved in executing the affairs of a deceased relative or who just want to be prepared for handling this complicated process, this is a very timely subject. Before we begin, if you've not already done so, please take a moment to complete the pre-survey that was emailed to you earlier. Go ahead and take time to do that. And as an added resource, glossary of terms will be emailed to all of the registered participants. You should have that in your email as well. It'll be a great reference throughout this webinar. Time has been allocated to respond to any questions that you may have. Please post your questions in the chat room and we will pause midway to answer your questions. And we'll also have time for your questions at the conclusion of the presentation. Finally, you are asked to complete a post survey. This will be after everything, which will assist in planning for all of our follow-up webinars. At this time, I'd like to introduce to you Tracy Boutte. She's the president of the Crescent City chapter of the Links Incorporated, who will bring greetings from our members. Good evening, Tracy.
Greetings and welcome from the Crescent City chapter of the Links Incorporated to our webinar this evening. I'm Tracy Legault-Boutte, and I have the pleasure and honor to serve this chapter and our community as president. The Crescent City chapter of the Links Incorporated began as a special interest group established in 1981. The primary function of the group was to address disparities that exist for marginalized groups at the intersection of social inequalities. The group of women placed a special emphasis on addressing the needs of African Americans of low income. The group expanded to broaden programming and to subsequently increased impact. Today, the Crescent City chapter of the Links Incorporated has 59 active professional women members that use their collective power to chart the course towards a more equitable city. Continuing to build on our legacy, we continue to implement innovative programming like this evening that addresses the social inequalities that exacerbate the vulnerability of people of color in our community. We invite you to continue our dialogue by attending our upcoming webinars. The status of women and children, the Bahamas, Haiti, Jamaica, and the kinship to New Orleans, transforming communities through art, what African Americans should know about organ donation, and HBCU networking seminars and HBCU Class Act scholarships. Thank you all for joining us this evening and enjoy the webinar.
Thank you so much for that. Now, everyone, there have been instances where families have had a difficult time managing the affairs of a loved one. So to illustrate real life experiences is Patricia Hightower, chair of the Healthy Homestead Committee, a Southern Area Signature Initiative of the Links Incorporated. Pat?
Good evening, everyone, and thank you for joining the webinar. As Camille mentioned, succession can be a very challenging undertaking, especially at a time when we're least prepared to close out the affairs of a deceased loved one. I'm going to share a few instances where failure to have the family's legal affairs in order through succession has resulted in adverse circumstances that prevented family members from acquiring ownership of property left by their loved ones. These examples demonstrate why the information presented in this webinar is so important. In the first example, a mother of 4 is seeking to refinance the home she lives in, to renovate it and to put on a new roof. She has worked hard and has a steady job and good credit. She and her 2 sisters were raised in the house following the death of their mother, who was an only child. Because there was no succession, she was unable to go forward with the refinancing at that time. In another example, a family home is now vacant after the death of the parents. The children want to sell the house, which was initially purchased by their grandparents. During the title search, they discovered several liens on the house from loans that were never repaid. Unfortunately, a succession was never done when the grandparents died. Once again, a family cannot move forward with their plans for their property. Another example illustrates a common problem. A family lost a valuable plot of land on the West Bank because there was no clear ownership of the property and no records of the property being maintained over the years with the taxes paid and the grass cut. However, they remember going with their grandfather to cut these same lots that he owned on this main thoroughfare over 40 years ago. Now, that same area on the West Bank is an expensive commercial boulevard, but was lost because liens were placed and the parish took the property. This valuable loss of property occurred because there was no succession. And last and most tragically, before Hurricane Katrina, so many in our community were living in their mother's or grandmother's house after they were deceased. In many cases, they were keeping up property insurance, property taxes, and flood insurance. However, the insurances and taxes were still in their mother's or grandmother's name. The house was destroyed during Hurricane Katrina. They filed an insurance claim and applied for SBA dollars. They discovered the insurance claim could not be processed, nor did they qualify for SBA funds because the property and the insurances were still in their mother's or grandmother's name. Again, a succession was never open. These examples highlight the significance of the information provided on tonight's webinar. Thank you.
Thank you so much for that and giving those real life experiences. Very enlightening examples indeed. And now I have the pleasure of introducing today's presenter and one of our Crescent City chapter members, Judge Carolyn Gill Jefferson, retired. She is a former member of the Civil District Court for the Parish of Orleans. She served as an Assistant Attorney General for the state of Louisiana and as Managing Attorney with the New Orleans Legal Assistance Corporation. Currently, Judge Gill Jefferson engages in the private practice of law. She's also of counsel with the Aaron and Gianna law firm and serves as a professional mediator, special master, and judge pro tem. In addition, she's an adjunct professor of trial advocacy at the Tulane University School of Law. Judge Gill Jefferson's tenure on the Civil District Court and her private law practice have provided relevant experience and insight into the legal process of successions. She is a subject matter expert on Louisiana inheritance law, property, and legal rights. To all in attendance, please welcome Judge Gill Jefferson. Judge, we look forward to your presentation. As we're working on getting the judge, we are definitely going to encourage you at this time to remember about those surveys. Also, this is a good time to go into your email and look at the glossary and just become familiar with some of the terms that we'll be using. So we'll get the judge ready in just a moment.
Thank you, Camille. Again, welcome to all of our participants this evening. All of the content that is presented here is for informational purposes only. For legal advice, please consult an attorney, and all information presented here is only applicable to Louisiana. If you have not already done so, please complete our pre-event questionnaire. If you want to understand wealth and inequality in this country, you have to understand Black land laws. When I was a kid growing up in Mississippi, my daddy always told us that you have to hold on to your land because they don't make it anymore. And he was exactly right. Land loss for African Americans have resulted due to the failure to timely transfer property after the death of the original owners. Taxes and liens, as Pat just described to you, that are not timely paid results in land loss. And finally, after tax sales have occurred, families fail to redeem their property timely. So why are we here this evening? First of all, 76% of African Americans do not have a will, more than twice the percentage of white Americans. Since 1910, Black families have been stripped of hundreds of billions of dollars because of land loss. Individual heirs can't use their land as collateral with banks and other institutions and are so denied private financing and federal home improvement loans. They aren't eligible generally for disaster relief. Hurricane Katrina laid bare the extent of the problem here in New Orleans, where 25,000 families who applied for rebuilding grants had heirs property. It is estimated that up to $165 million of recovery funds were never claimed because of these title issues. Individuals were not able to take advantage of SBA loans, road home loan grants, and property remains out of commerce. That is, that is not available for sale or refinancing. So to get to this evening's topic, what is a succession? A succession is the legal and orderly transfer of the property and debts of the deceased person to those who may inherit. Those who may inherit have the right to take possession of the estate after fulfilling certain requirements of law, and the right of those who may inherit occur at the moment of death. So when we have a succession, we have an estate. What is an estate? An estate is the property, the access, and debts that a person leaves after death. And what do I mean about access? Access is the ability to participate in an unopened succession. In Louisiana, married people govern themselves and their property under a legal principle known as community property. So what is community property? Community property is any property that is acquired by married persons during the course of their marriage. Each spouse owns an undivided 1/2 interest of that property. The surviving spouse takes full ownership of an undivided 1/2 interest of all of the community property at the death of the other spouse. The heirs of the deceased person inherits the other undivided 1/2 interest of all of the community property. And in order for the community property to apply to spouses, the spouses must reside in Louisiana. What is the use of fruct for the surviving spouse? Well, under the law, a surviving spouse shall have the use of fruct, that is, the right to use the deceased share of the community property not disposed of by a will. This use of fruct remains in effect until the surviving spouse dies or remarries, whichever occurs first. Now, the right of use does not give the surviving spouse to lease the property, to mortgage the property, or to sell it. Let me give you an example. Suppose spouses own a house before the death of the spouse. The spouse doesn't leave a will, but he has children. The surviving spouse, remember, gets her undivided 1/2 interest in the house, and the other half is going to be owned by the children. But the surviving spouse gets to stay in the house because he or she would have the surviving spouse usufruct, that is, the right to use it. Now, in Louisiana, we have two kinds of successions. One is an intestate succession and a testate succession. In the intestate succession occurs when the deceased person does not leave a will. A testate succession occurs when the deceased person has in fact left a will. So let's talk about intestate successions. The first thing we want to know about an intestate succession is who inherits in an intestate succession. The heirs. Though the heirs are the persons who are left behind, who inherit from the deceased person. And under our law, the law sets up categories of heirs who inherit in an intestate succession. First, it's the descendants, your children. Second, your ascendants, your parents. Third, your collaterals, that could be your aunts, uncles, or cousins. And finally, your surviving spouse. What you need to remember about these categories is that if there is one person's in the first category, the other categories cannot inherit in that particular intestate succession. So if you inherit, so the question becomes, how much does an heir inherit? Heirs inherit in equal proportions. Let me give you an example. If there are 5 surviving children, each child gets 1/5. If one child predeceases the parent, leaving 2 children, those 2 children will divide the 1/5 that would have belonged to their parent. How can one lose their right to inherit? Well, if an heir is convicted of a crime involving the intentional or attempted killing of the deceased person, if a judge or a jury determines that the individual participated in the intentional, unjustified killing or attempted killing of the deceased person. In addition, the heir who makes the charge that another heir has attempted to kill or in fact has killed the deceased person, that person must bring a lawsuit against the heir in the succession proceeding of the deceased person. That lawsuit must be brought within 5 years from the date of death of the deceased person. Now, getting an executive pardon does not affect the unworthiness of the person who might inherit. So, does the person have to accept a succession? No, they don't. Heirs can decline to accept or the intestate succession. Declining means that the heir does not accept the property and the debts of the estate. Now, to accept means that the heir takes the property along with any and all debts of the estate. Now, if there are more than one heir to the property and one of the heirs declines to accept that estate, then that portion that was declined will be divided among the remaining heirs. Let me give you an example. If there are 3 children and one decides that he or she does not want to accept their proportion interest, then the other third would go to his sisters and brothers. Therefore, those remaining sisters and brothers would get an undivided 1/2 interest. I finished my slides on intestate succession. So Camille, if there are any questions, I will take those questions now.
Okay, yes, indeed. We do have some questions in the chat room as we speak. So I'm just going to go down the row. And the first question, Judge, is when will the siblings be shown our father's assets by a sister who has not revealed anything to us? 13 other siblings. P.S. She has done his taxes for over 15 years.
Well, first of all, the question would come is whether or not the succession has been open. If the succession has been open and filed with the court, then she is required to list all of the assets and the debts of the deceased person. Then you will get the information that way. So if she has not opened the succession, now either one of the siblings can in fact open the succession, and then they can ask that information, the financial information regarding the deceased father, be brought into court. But they don't have to wait on the sister to open the succession. They can do that themselves.
Okay, let's get to this question. If you have the usufruct of a property that was willed to several members of the family, do you then have the right to take a loan out on the property without other family members' permission?
Remember what I said with the usufruct. It gives that person the right to use. The person who has the usufruct cannot lease, mortgage, or any way encumber the property. Now, the owners, the persons who are left the property as the owners, they would have a right to execute loans, but all of them would have to agree in order to do that. One person, the usufructuary, does not have the power to lease, sell, or mortgage the property. They can only use it. That is, stay in the property.
Okay, next question. Can I only leave my properties only to 3 of my children and not the other 3 who expressed no interest in my property?
That's a good question, and I'm going to cover that's a testate question because that person has left a will, and I will give you some responses to that. You can, and I will talk about disinheriting and forced heirship, so you will know exactly what measures you can take in leaving 3 children some property and the other 3 none.
We have one from Gaynell that says, when a sibling declines, does that need to be in writing?
Yes, it does. The sibling who is declining to accept the succession has to indicate in writing that he or she is in fact declining to accept the succession. And that, remember, that is in a intestate succession.
Okay, Judge, if the parents were married after the property was sold to the father, does the mother get community property rights? Good question.
Okay, let me see if I understand the question. If the property is sold, is that before one of the spouses die or not?
It's unclear. If the parents were married after the property was sold to the father, does the mother get community property rights?
If I'm going to make some assumptions here to try to answer the question for it. I'm going to assume that maybe the spouses were divorced and there was community property. The house was community property and the property was sold. Then the spouse would get his or her undivided 1/2 interest of the property. Now, what's from the husband? And if the husband dies and has the property, that the community property interest of the wife has already been disposed of when that spouse bought the property.
Okay, so thank you for clearing that up.
Whoever has the ownership after the community has been ended, then that spouse would be able to do whatever he or she wishes to do with the property in a testament, in a will.
And how about what if one of the heirs cannot be found when trying to open a succession?
You can open a succession even if you don't know where all of the heirs are. You can open the succession and recognize that heir who you cannot find interest in the property. Now, if that will depend if you are going to do a simple placing in possession, and that's going to be some things that we can discuss in our future webinars. But yeah, you can go ahead and open the succession even though you cannot find all of the heirs. You have to recognize their interest in the property. Now, again, can get into some administrations of estates, and you will be able to hold in trust, so to speak, the value of the property that the absent heir would be entitled to.
Okay, let's get to a few more questions before you continue your presentation. We have a lot here in the chat room. Can a deceased person disallow usufruct to the living, surviving spouse in his or her will?
Let me repeat the question so I can make sure I'm understanding the question.
Sure. Can a deceased person disallow usufruct to the living, surviving spouse in his or her will?
Yes, they can. And we're going to talk about that in a moment. Yeah, if you by will, you can dispose of the usufruct. The only way that the surviving spouse gets that usufruct if it is not disposed of by will.
Okay, gosh, this is great information tonight. Thanks so much. And what is the role of an executor? What are their rights exactly? If you could break that down for us.
I'm going to get to that in just a moment when we talk about testate successions, because the executor or executrix is going to be the person who's designated in the will to handle the affairs. And so maybe when we hear that discussion on that, I can answer that question. If it's still unclear, I will come back to it.
Okay, well, on that note, Judge, why don't we go ahead and continue, and let's get to the part 2 of your presentation. We had some very thoughtful questions. I'm sure we'll get much more as your presentation continues. So please continue with your presentation, and I will keep track of questions.
Thank you, Camille. Testate successions. Successions are those where a person leaves a will, and the person making the will is called a testator if the person is male, and testatrix if she's female. So what is a will? A will is a written document that takes effect at the date of death of the donor, by which he disposes of all or part of his property. A will can be changed during the lifetime of the donor. There are no oral wills in Louisiana. If my mom says that I am going to leave my jewelry to my daughter, she needs to put that in writing, because it does not, the transfer of the jewelry will not happen by her merely saying, I'm going to will my property to my daughter, my jewelry. What are the requirements to make a will? Well, under Louisiana law, you have to be at least 16 years of age, and you must have the mental capacity, the mental condition, the ability to comprehend and generally understand the nature and consequences of the will that he or she is making. Now, the lack of mental capacity is generally one of the primary reasons that people use to attack the validity of a will. And there are some others under Louisiana law, but those will be appropriate for another discussion. But always know that when you're making a will, the person must have the necessary mental capacity to understand and comprehend the nature of what he or she is doing and making a will. Now, as I said, in Louisiana, there is this principle of law called forced heirship, and it only comes into play when we're talking about testate successions. And it only applies in testate successions. Now, historically in Louisiana, forced heirship applied to all children regardless of their age. Now, beginning in January 1996, the legislature changed the definition of what a forced heir is. And a forced heir now are children who, at the time of death of the deceased person, who are 23 years of age or younger. Then in 2003, the legislature added another element of the definition of forced heirship. The legislature now adds that children of any age who, because of mental incapacity or physical infirmity, are permanently incapable of taking care of their persons or property at the time of death of the decedent. Medical information is necessary to establish this disability. So, if you've got forced heirs, that is children who are under 23 years of age or children who are totally and permanently disabled, how much of your estate must you leave for those forced heirs? Well, the law provides that if you have one child at the time of your death, then 1/4 of your estate has to be left for the forced heirs. If you have 2 or more children at the time of your death, then 1/2 of your estate must be left to your forced heirs. Now, how do I make a will? What is the forms of making a testament? Let's talk about those. In Louisiana, there are two, an holographic will and a notarial will. Let's talk about the holographic first. An holographic will must be entirely written, dated, and signed in the handwriting of the person making the will. The date can appear anywhere on the will, and the will's writer must sign at the end of each page. Anything that is written after the signature has no effect. So basically, when you're writing an holographic will, all you need is a piece of paper, and you sit down using your own handwriting, put a date on it, sign it, and that it will be a valid holographic will in Louisiana. The next type of will is a notarial will. The notarial will must be prepared in writing and dated. These wills are generally typewritten. It must be executed in the presence of a notary and two witnesses. The person making the will has to state that the writing is, in fact, his or her will. The person making the will has to sign his name at the end of all of the pages of the will. Notaries and witnesses cannot be named in the will. So I know I can make an holographic will, I can make a notarial will. So what can I put in a will? Well, the will, first of all, will allow you to make specific bequests to specific individuals, i.e. you can leave the car that you own to your son. The will can also include, you can direct how your debts are to be paid from your estate. You can name an executor and an alternate executor. You can name an attorney to represent the executor and the estate. You can include a provision to disinherit. And I think that probably goes to the question that Camille had just a moment ago about whether or not you can leave your property to three persons and not the others. And finally, the will can provide that the executor does not have to post a bond. So let's kind of talk about these individual bequests here. First of all, the executor is a person that the person who's making the will feels comfortable with, trusts that that person will in fact carry out the wishes of the person making the will. It doesn't have to be your oldest child. It doesn't have to be your surviving spouse. That's a choice that the person who's making a will gets to make. Then the other provision, that is naming an attorney to represent the executor and the estate. In recent years, the law has changed that allows the executor to choose an attorney to represent them and the estate other than the one that was named in the will. And the reasons for that is that the executor may not have confidence in the attorney may not be available to do the work, the attorney may in fact have passed on as well. So the fact that a person names an attorney in the will does not mean that the executor has to in fact use that attorney. And the last provision I want to talk to you about is the provision that the person making the will, the testator, can provide that the executor does not have to post a bond. The bond under normal circumstances would be required to make sure that the executor performs his or her duties in making sure that the property is distributed in accordance with the will. Now, if the testator does not say in the will that the provision for a bond is waived, then the court will set a bond based upon the gross value of the estate, as I said, to ensure that the executor will handle the estate timely and will make sure that the executor gets all of the property that has been left to the legatees according to the will. Can a will be changed? Yes, it can be. A person making the will, that is the testator, can revoke his or her will at any time before the death. So how do you do that? Well, the first thing you can do is physically destroy the will or have it destroyed at your direction. That is literally tear it up. You can make a new will and declare in the new will that you are revoking any previous wills that you would have made. And you can do a whole separate writing, and that writing to say that you put it in your own handwriting, that the person making the will is stating that any previous wills that he or she made are now revoked. Now, the question becomes, if I'm making a will and I've got children, can I disinherit them? Yes, you can. And children can only be disinherited in the same format that you make a will, either in the holographic form or in the notarial form. You must have a just cause or reason to disinherit under the Louisiana law. You must identify the name of the person that you choose to disinherit, and if you don't identify them by name, you must give enough information so that you can identify who that person is. And there must be just cause to disinherit children is specifically provided for by law, and no other reasons will be considered. The acts that will cause you to disinherit must occur prior to the execution of your will. So under Louisiana, what are these just causes? Well, there are a number of them. And remember, these are the only reasons that you can disinherit a child under Louisiana law. First, the child has raised his or her hand to strike a parent or has actually struck a parent. A mere threat to do so is not sufficient to disinherit. The child has been guilty towards a parent of cruel treatment or any other grievous nature. The child has attempted to take the life of the parent. The child, without any reasonable basis, has accused a parent of committing a crime for which the law provides that a punishment could be life imprisonment or death. The child has used any act of violence or coercion to hinder a parent from making a will. That is, the child has tried to prevent the parent from making a will. The child who is a minor has married without the consent of the parent. The child has been convicted of a crime for which the law provides that the punishment could be life in prison. And finally, the child, after attaining the age of majority and knowing how to contact his parent, has failed to communicate with the parent without a just cause for a period of 2 years, unless that child was actually on active duty in the United States Armed Forces. Now, under Louisiana law, we provide for small successions. Not every estate has a lot of assets. So the law provides for having what's called a small succession. And you don't have to have a court proceeding in order to do a small succession. Now, small successions only apply when the gross value of the deceased property is $125,000 or less. This has been increased in the last year or so. It was before when it used to be a smaller amount, but because of the changes in values of property, the small succession value has gone up to $125,000 or less. The deceased must have died intestate. And the only way that you can open up a small succession is it has to be done by an affidavit by at least 2 persons, including a surviving spouse, if any, before a notary. And when I say an affidavit before a notary, it has to have 2 witnesses and, of course, the notary. So what does the affidavit have to include? First, you have to know the date and time of death of the deceased person, where he or she was domiciled, the marital status of the deceased, and his or her last known address. You have to state in the affidavit that the deceased person died intestate. You have to list the name of the surviving spouse, if any, and give that surviving spouse's address and domicile and the last known residence. You have to include the names and last known address of the heirs of the deceased person, A description of the property that has been left by the deceased person, whether that property is community property or separate property. You have to show the value of each item of property as well as the aggregate of the total. The total cannot exceed $125,000. You have to include a statement describing the respective interest of the heirs, i.e. they're entitled to a 1/2 interest, a 2/3, or whatever the number of heirs there are. And remember that heirs always inherit in equal portions. And you have to have an affirmation by the heirs that they are in fact accepting the succession. And that affirmation can in fact be in the affidavit itself. Now, signing the affidavit you sign it under penalty of perjury, that the information that is contained in the affidavit is true and correct to the best of your knowledge and belief. And generally small successions happen when there's the only asset that's left is a bank account. You do this affidavit, take that affidavit to the bank with the information regarding the account, and the bank will then turn over the proceeds to those heirs who have been described in that affidavit. Now, how does one open a succession? Well, as I said, if the property is $125,000 or more, it is a judicial proceeding is required. Even if you make a will, that will does not take effect until it is presented to the court to open the succession. The succession must be filed in the district court of the parish where the deceased was domiciled at the time of his death. If they are living in Orleans Parish, then it has to be filed in civil district court. They live in Jefferson Parish, it has to be filed in the 24th Judicial District Court. Now, in opening the succession, you have to provide an affidavit that establishes the death, domicile, and marriages and relationship of the heirs. This affidavit is called an affidavit of death and heirship. Now, what documents do you need to open a succession? First of all, you need to know the name and date of death of the deceased persons. You do not have to have the death certificate of the deceased person at the time you open the succession. You can execute the affidavit, and the affidavit would say that the name and the date of death of the deceased person. You have to know the last known address of the deceased. You have to know the names of the surviving spouse of the deceased, if there are any. And if the deceased person has been divorced before, you need to name those spouses and if the reasons for the termination of those marriages, i.e. the death or divorce. And the names of all the children, a list of all of the assets, a list of debts, including funeral expenses and last illness, if there are any, and the legal descriptions of any immovable property. And finally, I want to thank all of you all for attending this webinar this evening. And Camille, we can start to answer those other questions that our participants have given to us in the chat room.
Okay, sounds good. I'm going to the chat room right now. We have several questions. I'm just going to start from the top and take it right down. Let's see. Adult children must be disinherited per the classes the judge discussed. A parent always has to explain why he disinherited, even if an adult.
Yes, they do. As I went over in the slides, the reasons that are set out as a matter of law are the only reasons that you can use to disinherit your adult children.
Okay, next question. In an intestate situation, can deceased property be sold while succession is being opened?
This property can be sold. This webinar did not include what happens after the succession proceeding is started. What we're talking about is the administration of an estate. And so when you have several pieces of property, one of the heirs can go into court and ask to be appointed the administrator of the estate. And as the administrator, they can ask the court for permission to sell the property. Now, there's some other legal requirements that go with it about advertising and the like, but those are the steps, and those are going to be the subject of our other upcoming webinars on successions. What is the process once you get into court? But yes, property can be sold while the succession is going on, and that money has to be deposited in a specific account, and so the heirs can then be put in possession of it once the estate is closed. But those are topics that we're going to get into in our next set of webinars on the actual handling of the court proceeding for a succession.
Okay, sounds good. And Judge, this is a question that we're getting several times. What is the average cost of having a will prepared?
Again, it depends upon the attorney that you get. You need to consult with an attorney to get that, and that it'll just depend. I can't tell you what those costs are. And again, that's going to be dependent on the attorney you choose, what that attorney's expertise is.
Okay. And if a home has a current mortgage on it, does that contribute to the value of assets?
You will list the house will have its own value, and you will list as a debt of the estate the mortgage. So if, like in all situations, mortgages reduce the actual value of the property. If the house is worth $97,000 and you got a $50,000 mortgage, then the mortgage got to be taken away from the value. But in the succession proceeding, you will list the actual value of the property, and then the mortgage will be listed as a debt of the estate. And remember, as I pointed out in the presentation, if a person wants to leave the estate and say what debts get paid from the estate, that mortgage can in fact be paid from the assets of the estate before the heirs get anything from it. But that's if the person makes a will.
Right. And again, how much time does it take to complete a succession? It could take some time, and I guess it's a case-by-case basis.
It is a case-by-case basis. For instance, if you have an intestate succession, you can go into court. If all the heirs are in agreement, you can ask the court to put all the heirs in possession of the estate. And that's a matter of filing the requisite documents with the court and ask to be placed in possession. That can take generally a day or so, but it doesn't take a long time. It just depends upon the assets of the estate, what the debts are, the agreements that can be reached among the heirs in terms of concluding the estate.
Yeah,
now,
I think a lot of people have
that.
Yeah, I mean, you hear this all the time that, oh gosh, it's going to be such a burdensome issue and it's going to take so much time. But really, if ducks are in a row, it can be a seamless process.
It can be a seamless process.
Okay, if succession was opened on the property, does that include contents of the home?
Again, that will depend upon the kind of succession we're talking about. If we're talking about an intestate succession, it will be included as an asset. All of the furnishings, all the jewelry, bank accounts, cars, any asset that the deceased person has can be included in the succession.
And let's talk about inheritance. Is inheritance considered community property?
No, an inheritance is not community property. That's a topic that can require some discussion, but anything that you inherit, even during the course of your marriage, is going to be your separate property. And it makes sense because in Louisiana, the law wants to make sure that everything stays within the family, so to speak. So if you inherit a piece of property during the course of your marriage, your spouse does not own an undivided 1/2 interest on that property.
Okay, great question. Next question. Can you avoid succession and the fees involved if you have a revocable trust instead of a will?
Can you avoid a succession if you have a, no, unless the trust doesn't transfer the ownership of the property. Remember, successions is the legal orderly transfer of property. Now, the trust can be made part of a will to say that in my will, I'm leaving a certain amount of property in trust for a person, but the will still has to be probated.
Okay, gotcha. Good question here. If you're an only child and you are the sole heir, is succession even necessary?
Yes, it is. And I think that's where people think because my mom has died and I'm the only heir, I don't have to do anything. Well, the property is going to remain in your parents' name until the succession is done. That's what the succession does for you. It transfers the ownership of the property to you. If you never take it out of your mom or dad's name, even though you're the only child, you are not going to be able to do anything with it. If you recall Pat's examples where people never did anything with the property, it was in grandma and grandpa's name or mom and dad's name. If something happens, then that the only child can't do anything. You have to do a succession in order to transfer the property after the original owner has passed away.
Judge, this is such great information. We have so many questions. Next up, can an heir allow one of their children to live on a deceased person's property if there is more than one heir?
That becomes kind of tricky because really the child of the heir doesn't have any legal right to the property. And I have experienced that where once a child is living in the property and the heirs, the siblings of the heirs come along and say, whoa, well, we want this child to pay rent because they're not entitled to any ownership interest in the property. I can tell you if that happens, then the other heirs may come in and say, we want that child to pay rent because they are not the rightful owner of the property.
Okay, someone is asking, where can I retrieve the vocabulary words from? Just a reminder, for everyone who's registered, you should have gotten an email with a list of glossary words that we can refer to, you can refer to if you have questions on what something may mean or just need a clear understanding of what's being talked about. So that's just a reminder. Judge, question. If I have a notarial will and want to update my will because I purchased more property, can I update my will with an holographic one?
Yes, you can. And with the holographic will, you have to state that you are revoking the previous one that you made. In the holographic will, you have to say, I am revoking my previous wills. And if you remember the date or have the dates that you can specifically say. Now, remember when you do the holographic will has to be in your own handwriting, dated and signed. Can't be typed.
Okay, which actually springboards to this next question. Does it matter if a handwritten will is written in cursive or printed by hand? Let's talk about why this matters.
It doesn't matter if you print it, if that's the way you use your handwriting. If you print it in manuscript, that's fine. But you got to put your signature on it. It can be written in cursive. Again, you have to have your signature on it. It has to have a date on it, and it's got to be in your handwriting. And if your handwriting is manuscript, so be it. But you have to sign it. And if you can't write your name, you can make an X. However you sign your name, you can do that.
Oh, you can put an X?
If that's the way, if you can't write your name, yes.
Okay. Next question, and this is referring to Susie Orman, the financial guru who we see on TV. Someone is asking, can I use her will package in Louisiana? I'm not sure.
Well, first of all, I don't know what is this in Susie Orman's package, but if you're using Susie Orman's package, you must make sure that, and I'm assuming it's probably something that's typed written. And if it's typewritten, then you're going to have to get it notarized and witnessed by 2 persons in order to have it valid in Louisiana. Now, if you want to take the Susie Orman package and write her words in your own handwriting, you can make an holographic will, but I can't say whether or not Susie Orman's package would comply with Louisiana requirements of a notarial testament or an holographic testament.
And does an holographic will need a witness or witnesses?
No, it does not. It just have to have it has to have a date on it. It has to be in your handwriting and it has to be signed. It does not require notary.
Okay, a couple of questions on the same topic. Is it more advantageous to create a trust than a will?
You can create a trust, but if you want to dispose of your property and transfer ownership, you got to do a will.
Yeah. There are a lot of details involved in this, Judge. And what would you say for people who, is there a go-to handbook? Is there a place for resources other than our fabulous webinar and the amazing information that you're giving?
Well, certainly you can always consult an attorney about how you want to, what to do with your estate. I would suggest that is the best place to do it. Certainly the civil code that outlines all of the requirements of making a will and the like is available, but I would suggest to you that may not be the easiest way. I would suggest that if you can go to seminars or get information, but most importantly, consult an attorney to talk about what the specifics are and how you want your estate to be handled at your death.
Okay, next question. If a will has never been done for several generations, is there a particular order that succession must be done?
Well, you always start when you're opening a succession, and if you will always start with the original owner of the property. Say, for instance, you had a piece of real estate, and the real estate was in your grandfather's name. Well, you have to open up the grandfather's estate first, and then if he had any children, pass it on to his children. And then if some of his children are now deceased, then it would be passed on to their grandchildren. But that's only in an intestate succession where there's a legal principle called representation. And it's an easy concept to understand that if your parent is deceased and you're trying to open your grandparents' estate, you can represent your parents in your grandparents' estate.
I just want to add this, Patricia Hightower, who is the chair of this Healthy Homestead Committee, she put a note here in the chat room. I want to pass this along to everybody, that a book that is helpful, Personal Finance for Seniors, it's called. It's by editors of FCA Publishing. So I guess for folks who need a little more information or a little guidance in this area, that might be a great resource. And Pat, thank you so much for sharing that we can pass along to all of the participants here today. Okay, Judge, next question. A deceased person or a decedent has one child who may decline her mom's estate. Can she then pass it to her children, the deceased person's grandchildren?
If we're talking about an intestate succession, is that person the only child? Read the question again, because
has one child. Yes, one child.
Can she pass it on without accepting her mother's estate?
Correct.
No, she can't.
No. So once you decline, then
if she declines to accept the mother's estate, she can't pass it on. You can't decline. Think about it. You can't pass on something that you have not taken ownership of.
Okay. Thank you for that. Oh, everyone is wanting to know about things being notarized. Can you touch on that just briefly for us again? What needs to be notarized? What doesn't need to be notarized?
Okay. Well, let's talk about the intestate. If a person dies without a will, so you don't have to worry about notarizations. Intestate succession. For a will, the will has to be notarized if you're doing a notarial testament. That is, you're going to a lawyer, he or she is going to type it up and put all of your bequests in it. That has to have a notary and 2 witnesses. An holographic will that is written in your own handwriting, dated and signed, does not have to be notarized to be valid.
Okay, thank you for that clarification. Next question. If a property is an LLC, does a succession still have to be opened?
If you're going to transfer ownership of the LLC, the succession has to be open. Remember, the LLC will remain in the person's name after he dies. It doesn't go to anybody else unless there's some other agreements about what happens to the LLC among other members. If it's a sole member LLC and the member dies, the assets of that LLC cannot be transferred unless a succession is open.
Okay. Can you access bank accounts with just a will?
No, you have to have the will probated. The only way that you can access an account if there's a joint account and both parties, the person who's going to the bank to get the funds name is on the account prior to the death of the other person. You will have access if it's a joint account, but just to have a will that says John Jones gets my bank account at the Whitney bank account, you can't take that will to the bank and get it. The bank is going to require that the will be probated, that is presented to the court for, and they use the word probate, but to open the succession, but just taking the will to the bank will not get you access to the bank funds.
Okay, that's good information. If one has a minor child, what steps can he or she take to keep the child's mother, so let's start over. If one has a minor child, what steps can he take to keep the child's mother from controlling the property assets upon death?
As the minor child, you have to make the provisions in your will. If you're going to execute a will, you need to, and the child is going to be the recipient of one of the bequest. Is that the question? The child is a recipient of the bequest, and the testator wants to make sure that the mother does not have any access to whatever the child is inheriting. Excuse me.
It appears that way, yes.
I would suggest that you talk to an attorney about the specific ways that you can handle that. It'll depend upon the custody of the child, but that's something, because of the specific nature, will require some advice. And we're only giving information tonight. I'm not here to give any specific legal advice. And I think that's one of those questions that you would have to consult an attorney and lay out all of the specific facts regarding the relationship between the parent and the child.
Okay. Does the $125,000 limit of value of the property only include homes, or does it include bank accounts as well?
It can include any asset of the deceased person, but the aggregate, that is the total, cannot exceed $125,000 to do a small succession. You can have real estate, because the real estate could be worth $25,000 or whatever. But as long as the total assets, bank accounts, vehicles, and property does not exceed $125,000.
We're getting several requests in our chat room, Judge, to repeat the resource book that we mentioned earlier in this webinar. I just want to repeat it for everybody. It's called Personal Finance for Seniors, and it is by FC&A Publishing. So if you were wanting to write that down or have that for your files, for your personal information, it's called Personal Finance for Seniors, of something tangible you can put your hands on. Okay, Judge, next question. Can you talk about taxes in regard to inheriting one's share? Good question.
If you inherited, there are no taxes on it.
Oh, simply put, right? What is the difference between a traditional power of attorney and a durable power of attorney?
Well, I didn't cover that, but I'll answer the question. A power of attorney is a durable power of attorneys generally give persons at the opportunity and the ability to handle all aspects of a person's property. Now, what you must know about powers of attorney terminate when the person who makes the power of attorney dies. It has no more effect. The fact that they use durable does not mean that it extends beyond death. Because remember, what a power of attorney says is that this person has the power and ability to represent me. And if you're no longer alive, there's no need for any representation.
Okay. Let's see. Is there a time limit to probate a will? Will written in 1975, died in 2009. Is it too late to open succession?
Absolutely not. You can open it as to make the transfer of the property.
What happens, and forgive me if you already answered this, what happens if a person dies in another state but owns property in Louisiana? Did we ask that already?
No, but if a person dies in another state and has property in Louisiana, if they have property in both states, let's use an example. If a person died in Mississippi but had property in Louisiana and property in Mississippi, you can open the estate in Mississippi. And once that's concluded, then you can come to Louisiana and present that open estate, and then the court will then issue a judgment in accordance with the, if there was a will, or in accordance with what the judgment of the Mississippi court, and to handle the Louisiana property.
Next question. What are the legal requirements of an executrix in the case of intestate succession? Time requirements to execute duties. What is the obligation of the executrix, and what is the obligation toward their siblings?
Okay, the first obligation of the executrix is to present the will to the court for probate, to open the succession. The executor is bound to carry out the specific bequest in the will. And what was the other part of the question?
What's the obligation that the executrix has toward the siblings, and what is there a time requirement on the duties to execute the duties?
There's no real time requirement, but they should handle it as expeditiously as they possibly can. The executor's primary duty is to present the will to the court for the court to open the succession, and then deliver the property to the respective person, the respective legatees under the will of their purport, whatever the bequest has been made to them. For instance, if the person has been willed the card, then you need to get the card to them as quickly as you can.
Can an executrix or an executor be compensated for carrying out the responsibilities?
Yes, they can. If the testator has the ability to say how much that the executor will get. If the will is silent as to compensation for the executor, Louisiana law provides that the executor can be entitled up to 2.5% of the gross value of the estate for handling his or her duties.
Okay, just a few more questions because we have about 15 minutes left here. Do mortgage companies acknowledge a living will? If one half of an unmarried couple's name is not on the mortgage, will he or she have to vacate?
Well, first of all, a living will has to do with health concerns. if a person has left a will, the mortgage company the mortgage is always going to be the debt of the estate of the named owners of it. So if the deceased person left a will and he left his share of the property to his children or to his spouse, the mortgage is always going to be recognized first. You don't get out of a mortgage just because you make a will. The mortgage has to be paid in order for the legatees under a will to be able to take it. Now, the legatees can accept their bequest subject to the mortgage on the property. So the mortgage is always going to be there. It doesn't go away just because you pass away.
Okay, gotcha. The next question, does a wife have community property rights if the husband acquired the property before they were married?
That question it's a good question, and it has several parts. If the person acquired the property prior to the marriage, it is not going to be community property unless the spouses make some agreement in writing after they're married as to who owns the property. And that is part of my class that I teach in community property. Not succession.
We should all just come take your class, Judge. We would be all better
on
for it.
community property. As a matter of fact, I'll start in the spring.
Okay, next question. Is it wise to have your lawyer be the executor as well?
Again, that's a decision that is going to be made by the testator. If they trust the lawyer and believe that the lawyer will handle his or her estate effectively and make sure that all of the bequests get to the legatees, certainly there's no prohibition on having your lawyer named the executor of your estate.
Really good question here from Miss Clayton. What should heirs do if an executrix is dragging her feet in executing her duties?
If the will has been presented to the court for execution, the succession has been opened, the heirs have a right to go into court and ask the court to remove that executor for failing to handle the affairs of the estate. Now, they have to present certain facts to the court, and the judge will make a decision based upon the facts and evidence that is presented to them as to whether or not the executor can be removed. It's going to be in the discretion of the judge after, there's this legal term, after reviewing all of the evidence, the judge gets to make that decision. But you can petition the court to have that executor removed if they're dragging their feet.
Dragging their feet, I mean, who determines what dragging their feet is?
That's why
again, we're getting to that timeline.
Yeah, what I mean by dragging their feet, if the succession has been open a number of years and if the heirs have not been put in possession of the estate, either by terms of a will or if it was again we can have an administration of an intestate estate as well. But if they haven't done what they're supposed to do, you can go in and ask the court, and the court you have to present evidence, and then the court, after a hearing, the court will just not sign an order summarily moving a person as executor, but they have to go into court and present evidence such that the court will make a determination as to whether or not the executor should be removed.
Okay, perfect. Thank you. And one of the last few questions, Judge, hang with us. If I purchased a property with separate funds during marriage and I want to leave that property to a grandson, what's the right way to state that or to present that in my will?
You just specifically identify that property as your separate property and that you're leaving it to your grandson. Remember, when you're executing a will, you can make the bequest to whomever that you choose to, unless that you have a forced heirs.
Okay. Short question. Let's see if we can sift through this. What if the succession has not been opened yet?
If a succession has not been opened, an heir can go into court and petition the court to open the succession. They can either do it by saying, all of us agree and we want to be put in possession, or they can petition the court to open the succession by administration. And again, that's one of the topics that we will address when we do a webinar specifically on wills and the process once it gets into court. Once you file it, what happens? And we will have a future webinar coming up to discuss in detail that aspect.
Okay, I'm going to go ahead and call this the second to last question. Is an out-of-state will legal in Louisiana? And can you also disinherit an adult child?
An out-of-state will be valid in Louisiana as long as that will was made in accordance with the requirements of a will in the state where it was made. So say for instance, like if you make a will in Louisiana and you move to New York, well, as long that will can be probated in New York as long as it met the requirements of Louisiana law, either as a notarial will or as an holographic will.
Okay.
What was the final part of the question, Camille? I think I forgot.
Can you also disinherit an adult child?
Yes, you can disinherit an adult child. But you can only disinherit that adult child under the specific reasons that I gave earlier in Louisiana. And remember,
Okay.
all of the things I've talked about are specifically applicable to Louisiana law.
A follow-up on that is if you cannot disinherit a child, but you say you can, but it says if you cannot disinherit a child of the just causes, can you just leave them a small amount, like let's say $1?
You can, if you're executing a will and that child is not a forced heir, i.e. not under the age of 23 or disabled, you can leave that child $1. And if all of your children are 23 years of age or older at the time that you execute your will, you don't have to leave them anything. They're not forced heirs, even without disinheriting them.
Okay, great information. Okay, Judge, this is going to be my last question for the evening. We could talk about this forever. We have so many questions in the chat room. I cannot wait for our upcoming webinars to continue this discussion and many others. What happens if the family member dies with more debt than assets?
If he dies with more debts than assets, again, you don't have to open the succession, but if you want the property to be transferred, you have to do that. You don't have to open the succession, but it's always best to open one if you want to transfer property. And if it's more debts than assets, then whatever. And if the debts are mortgaged, then the mortgagor always has the right to come in and seize whatever assets that are left to pay his mortgage. You may not get the whole amount, but they can in fact come in and seize it if they like.
You know, one thing you mentioned was, a lot of this came to the forefront and sort of rose with the water, if you will, no pun intended, during Hurricane Katrina. Why do you think that was such a big deal, and why it's just been such a hot topic since then?
I think part of the problem has to do with that most people don't like to think about what happens with their property after they're gone. They don't want to talk about it. They don't want to maybe even face their own deaths. But for us here in New Orleans, it was comfortable for people to kind of leave things as they are. And it wasn't until, as I pointed out in my earlier slides, that when people needed to make claims for insurance or in order to apply for FEMA grants or SBA grants, none of those grants were going to be granted because the persons who were there sitting in front of them were not the title owners of that real estate. And the only way that mortgages can be given is if they are the title owners of the property. I think again is that people just don't want to think about what happens with their property after their deaths. and it leaves a great void, and it has been particularly devastating to the African American community. Camille, if I could just have one final word, I'd like to thank everyone for participating tonight. I'd like to thank you all for your questions. I hope all of our information that we have given to you has been, in fact, informative, and we look forward to our upcoming webinars on this particular topic. Thank you again.
Excellent. Judge, thank you so much for your insight and for your knowledge and for breaking it down to us in a way that we can all understand. Thank you so much. I'm going to go ahead and close out the chat room. Thank you so much. Okay, on that note, to all the participants, we certainly want to thank you. This has been the most and just amazing and informative session for us. We just want to remind you that at this time to take a moment to complete your post survey. Be sure to complete your post survey. Very important for us. That'll be important for us as we move forward and as we do future webinars as well. Speaking of future webinars, we have several of them coming up. This, of course, the first in a series of webinars that we're going to host for you. I would like to tell you that we have an upcoming webinar entitled The Bahamas, Haiti, and Jamaica, and the Kinship to New Orleans. Also, we have Transforming Communities Through Art. We have What African Americans Should Know About Organ Donation. And then we have HBCU Networking Seminars and HBCU Class Act Scholarship. So those are the ones that should be coming up next. And of course, we will keep you posted and also keep your eyes peeled as we continue to keep you updated and to keep you informed on when these will be coming up for you. At this time, we would like to thank the Crescent City chapter for planning this webinar for all of us. A very special thank you to our presenter, Judge Carolyn Gill Jefferson. Very informative. Thank you so much. Also, we want to thank Gina Swanson and Angeline Jefferson. And to those participating in this webinar, we thank you for your time. We thank you for your attention. Thank you so much for all of your comments in the chat room. They mean so very much to us all. And we look forward to hearing from you. If you have continued questions, go ahead and put them in the chat room. At least that way we'll have them archived, and we'll have them available so that maybe we can use them next time when we do another webinar or when we talk about this presentation or this topic once again. Again, we leave you with greetings and blessings. We certainly hope that you all stay safe and have a happy holiday season. Thank you.